May I plead your worship? My lord, item number 24, my lord, the orders matter, my lord. My clerks, my lord, I'm informed the step has not taken, my lord. So my some time may be given, my lord. This matter may be fixed on item 24, my lord. Today I incur my lord, step not taken, my lord. I've informed
Mr.
S committee.
SK Medi, line STGC. Praise for how much time?
My lord, 3rd of March, my lord, matter fixed, my lord.
No, step not yet taken, you said?
Yes, my lord. So my lord,
You are taking steps?
yeah, today I'm taking, I'll
Okay.
take step, my lord.
Submit steps. There was a direction to take a step, however, inadvertently, he could not take steps. And praise for allowing him to take steps within 2 days,
3 days, my lord.
within 3 days from today. Prayer alert, step within 3 days is directed.
My lord, date may be fixed.
There is a direction.
My lord.
Steps to be taken by what way?
My lord, earlier, my lord.
Speed post.
Speed post, my lord.
Okay, steps. Upon respondent number?
My lord, the two, all respondent, my lord.
Okay, respondents by speed post as well as by user process within 3 days from today. So list is matter after
On 3rd of March, my lord. Yes.
March. Okay. List is as prayed for, list is matter on 3rd March.
High level, my lord.
This is
24, my lord.
24. Okay.
High level.
Lordship, may I beg to mention one long pending matter, a part hard matter, Yagam Bogo versus Daso Bogo. This may be day after tomorrow, maybe fixed.
Okay.
Yeah, Lordship. Your Lordship, I beg to mention item number 25 on behalf of K. Tama, Your Lordship. I have already taken consent from the other party, Your Lordship. This matter may be fixed after 2 weeks, Your Lordship.
Okay. Mr. Said
Jay Singh.
Jesri. Danic Council for the Danic Council appearing on behalf of Mr. Ketama, Danic Council for the respondent. When do you want, you said?
After 2 weeks.
Pray for listing this matter after 2 weeks. 2 weeks, Mr. P. Pang, Danic Council for the petitioner has no objection. Prayer Allah, list this matter after 2 weeks.
There's an interim order.
The interim order passed earlier shall continue till the next date of listing. Okay.
Hello.
May it please your Lordship?
Yes.
Your Lordship, I beg to mention item number 4. Mr. G. Kauto, the land concept for the petitioner is out of station today, Your Lordship, and I'm appearing on his behalf.
This he submitted in an earlier occasion that this matter has become infructuous. You have any?
Yes, Lord.
You have any instruction that?
Yes, and I'm appearing on his behalf and seek a short adjournment.
Okay, adjournment. When do you want?
Your Lordship, after 3 weeks. Your Lordship, we have taken the consent of the land council for the opposite side.
Okay. You are Miss
Elori.
Danic Council appearing on behalf of Mr. G.
Kato.
Kato. Danic Council for the petitioner. With the consent of the Danic Council appearing on behalf of the respondent, pray for adjournment for 3 weeks. Prayer allowed. List this matter after 3 weeks.
3 weeks, yes. Deeply obliged, Your Lordship.
Item 24, my lord. Both my IE also. There is IE also. Item 24, my lord. Just now, your lordship pass order, my lord.
It will be listed along with the IA only.
Yeah,
It is listed.
step in both, my lord.
Okay. In IA also?
Yes, ma'am.
Similar order, huh?
Yes.
Item 24.
Lordship,
Yes.
Lordship, I beg to mention item number 12 and 13 with the consent of other party. I'm appearing behalf of N. Sharma. Kindly, this matter may be listed on 24 March 2026.
Why it has been listed for?
It's listed for orders.
Order for what?
Lordship,
You
I
have
just
taken steps? Yeah, for
Order.
respondent, okay. That's okay. You have correspondent number?
All.
Okay, including 5 and 6?
Yeah.
Okay, 5 and 6.
Oh, no.
No, 5 and 6, I think different.
Yeah.
The service not yet received. Okay, Mr. Sibo,
B. Sibo.
Danic Council for
On behalf of N. Sharma.
Hmm?
Yes,
This is item 20,
12 and
12 and 13.
12 and 13. OB 13.
Bobby Burton versus.
Okay,
Navratna.
oh, it is item 20 written, I think. Okay. Line counsel for the petitioner, as well as Mr. D. Pang, and line counsel appearing on behalf of the respondent number 1 to 4 are present. The service upon the respondent number 5 and 6 is still awaited in view of the above. Let this matter be listed. When?
24
3
March,
weeks. Huh?
24 March.
24 March,
Yes, no.
24 March.
I know this one, they don't have next.
Okay, let's pray for Kama. Let this matter be listed again on 24. Okay, March.
Lordship, another matter, item number 6. Kindly, this matter may be listed after 2 weeks.
Second appeal. Wait for the respondent
No,
in item 6. Wait for the respondent. Have you informed
yes, Lordship.
who is for the respondent?
Lordship, this not.
Okay, noted notes. You are appearing on behalf of Mr.
T. Tucker.
Shivu Lana Council appearing on behalf of Mr. Peter. Thank you. Huh? Pray for listing this matter after 2 weeks. Prayer Allah, list this matter after 4 weeks.
Develops.
Madam, this item number 3, madam. This matter may kindly fix on 3rd March, I've taken the council.
3rd March.
Otherwise, it's ready for hearing.
Okay. Mr. Rajesh, Lana Council for the both are okay. Both on the prayer of both the Lana Council for the respondent, Mr. Rajesh Sona. And you are
I put a petition.
joint prayer, okay.
Not a
Mr.
joint
Deepa.
prayer. Not a joint prayer.
Okay, Mr. Rajesh Sona, Lana Council for the respondent. Pray for, when do you want to say?
3rd March.
Okay. Listed for, pray for listing this matter on 3rd March to which Mr. Deepang has no objection. Prayer allowed. List this matter on 3rd March. Okay,
Interim order.
stop. The interim order passed earlier shall continue till the next date of listing. Okay.
My lord, I would like to mention item number 26. The lead counsel is not able to appear due to some personal issue.
Hmm?
The lead counsel is not able to appear due to some personal issue. So, we will adjourn to from there.
Okay, you are Mr.
So, Kiseng Manlong. Kiseng Manlong.
P.
It's Manlong.
Lana Council submits that the conducting council, Mr. V. Laji, is out of station, therefore pray for adjournment. For how, when do you want to sit?
Tomorrow or any next day. Tomorrow or day after tomorrow.
Tomorrow. Okay, we'll fix it on Thursday. Okay. List this matter. Pray for listing this matter on Thursday. The prayer is allowed. List it accordingly on Thursday. Okay.
Item number 1.
Madam, there's a caveat that may be discharged.
Okay. Mr. Deepang, Lana Council appearing on behalf, Lana Council for the caveat shall be heard. The caveat stands discharged, huh? Okay. Appeared and heard, huh? Okay, yes.
My lord,
Yes.
I have filed this petition under Article 227 of the Constitution against the impugned order dated 8th of January 2026, passed by the learned District Judge Pasighat in IA number 31 of 2025, in Miss Appeal number 5 of 2025, titled as Nindam Ratan versus Lending Pertin. The copy of the order is as Annexure P1. My lord, the brief facts of the case is that I am the absolute owner of the suit land situated at Moruk area, besides NH13, near Industrial Estate, Mebo Village, PO and PS Mebo, District East Siang, Arunachal Pradesh. Area measuring around 230 by 200 square meters, by way of a gift deed.
So where is the document? Can we see the document? You are showing that you are absolute owner.
Yeah, I have a gift deed. I don't have the original with me right now.
Hmm?
I don't have the original with me right now.
Okay, on what basis you are claiming?
Or gift deed, Your Honor. Gift deed, my lord.
Gift deed. Please.
Page number 21, my lord.
21,
21 and 22, 23.
not legible. Not legible. Page 23, that copy. Whether this gift deed was registered?
Your Honor, it's also registered because at the time there was no proper registration office in Mabo,
Where it was executed?
2001. And Your Honor, Supreme Court says that the legality, admissibility.
No, where it was executed? If
In Mabo.
this was executed on when
It's
and where?
23rd of January 2001.
Okay. Where? It's just privately or in
Private,
before the
in
before the
between
magistrate?
donor and donee and two witnesses.
Okay. Not before the magistrate.
Not before the magistrate, my lord.
Okay, who is the donor?
Late Raju Ratan.
Okay. He is still alive.
Oh, he has expired, my lord.
When?
Around 3 years back.
Okay. Thereafter, did you occupy?
Yeah, it was in my occupation. I was.
What did you do? Any apply for any allotment or land possession certificate?
No,
Have you
no, my
applied
lord.
for?
No, my lord, because it's a tribal land, so it was as it is. It was bounded by stones and sticks.
How do we know that it was under your occupation?
No, Your Honor, I have witnesses. I have witnesses, Your Honor. That's what the witnesses, list of witnesses and filing the
Then in
title
that
suit.
case, the matter is to be decided by the trial court only.
Yes, Your Honor, the trial court has passed a interim order that in order to preserve and protect this suit property, both the parties are restrained from creating any third party right title interest over the suit land.
Okay.
So the learned civil justice senior division has passed an
You
interim
filed
order
title suit.
on the title suit. Title suit number
Okay.
17 of 2022.
Hmm.
And the district judge has stayed the status quo of the passed by the learned civil justice senior division. Passing up.
Where is the order passed in your application
This is page number 36.
granting injunction?
Page number 36, my lord. Page number 36.
36.
36.
Para 21 onward, my lord, is available. There is a finding.
My lord, in para 25, the learned civil judge senior division says that the respondent is silent about the possession on the capacity of his possession over the suit land, my lord. The respondent doesn't have any ownership documents here, my lord.
Lies below the bank account. Under whose possession it is at the moment?
My lord, on 27th of March 2022, the respondent forcefully occupied the suit land. The suit land was in my possession from 21st of March 2001 to till 26th of March 2022.
Okay. So the respondent dispossessed you
Yes, ma'am.
and erected construction, installing iron gate, etc. The existing boundary wall on two sides. So the respondent has already constructed
Yes.
boundary wall as well, the gate also.
Yes, ma'am.
This was done in the year 2022.
22.
What did you do then?
Your Honor, after the trespass and forceful occupation, I sent complaint to the officer in charge of police station Pasighat. I sent complaint to the officer in charge of
Send
police
complaint means
FIR.
you filed FIR
I filed
before the
FIR.
police.
Police.
Okay, then what did
The police did
do?
not register the case. The police did not register the case. So thereby, on 18/7/2022, I filed a suit for permanent injunction along with suit for interim injunction. And thereafter, on 4/6
While
2020,
filing the permanent injunction,
interim
injunction.
injunction application.
Okay, did you claim a right title?
Your Honor, the London civil judge had given me liberty to file amended suit. So I have filed amended suit, Your Honor.
Now, the respondent is contesting. Respondent is contesting the case.
Yes, ma'am.
You are agreed by the order passed by
The London district judge,
district judge.
8th of January 2026.
The suit property, both the parties are restrained from creating any third party. Right, okay. The interest over the suit and only an object and proper of the suit. Will be in press construction. Okay. So this was challenged by the respondent. The order of the chief division,
Civil
the
judge,
senior judge, civil division.
yes, my lord.
Okay, and this is the, where is the impugn order?
This is on the second, just up, next to the index.
Hmm?
Next to the index. The original.
Next to the index,
Yeah, the original.
not annexed.
It is annexed, Your Honor, my lord.
Annex is,
In annexure P1, page number 16.
page 16. Okay. Partly allowed.
You know, the London District Judge has given liberty to the respondent to carry out any activities on the suit land, which shows that he has granted permanent relief at interim stage, my lord, which is against the principle of natural justice.
It says that applicant will not dispose of the suit land during the pendency of the title suit. So what is wrong in it? You are not under the possession. The land is not under your possession.
I have been dispossessed, my lord.
Hmm?
I was in possession from 23rd of January 2001 to till 26th of March 2022. More than 20 years I was in possession. They suddenly trespassed and forcefully occupied. And I had sent complaint to the police also. But the police also did not do anything.
It is observed that no prima facie case balance of convenience was satisfied by you.
No, the three principles.
No
is
prima
in
facie
my
case
favor.
established.
My lord, the three principles is in my favor. I have ownership documents. I had position.
No,
I had
no,
sent
says
complaint
that
to
you are
the-
not, no,
I had
you
sent
yourself
complaint to the
stated that
police.
the land is not under possession.
No, I was dispossessed, my lord. I was in possession for more than 20 years. I had sent complaint to the police, but the respondent does not have any ownership documents. They does not have any records to show that they have ownership. They are the owner of the land.
Yes. Yes. So,
Wait, please, Lordship.
yeah,
We are, my lord, under 227 jurisdiction.
yes.
Superintendent by your lordship.
Mhm.
The lordship knows this is a revision petition and scope of interference is very, very limited.
Yes.
Only to the scope whether, my lord, there has been a
Jurisdiction.
lack of jurisdiction on the part of the
Hmm.
first appellate court or not. Now, your lordship may kindly have page 36 for a moment first. This is the first order where your lordship will find, in fact, the learned civil judge senior division came to the conclusion that no case of granting an injunction was made out in spite of the past that order. That is why the learned first appellate court interfered. Your lordship have order 39 rule 1 for a moment, please. Under what three conditions the lordship know them just for the purpose of refreshing the lordships.
CPC.
Order 39. That's my lord.
Yes.
Wherein cases in which temporary injunction may be granted, wherein in any suit it is proved by affidavit, proved, my lord, by affidavit or otherwise, that any property in dispute in a suit is in danger of being wasted, damaged, or alienated by any party to the suit or wrongfully sold in execution of a decree, or that the defendant threatens or intends to remove or dispose of his property, dispose of, my lord, with a view to defrauding his creditors, that the defendant threatens to dispossess the plaintiff or otherwise cause injury to the plaintiff in relation to any property in dispute in the suit, The court may grant a temporary injunction to restrain such act or make such other order for the purpose of staying and preventing the wasting such and such and such, such and such. So these are the conditions that will have to be fulfilled, my lord. Now, this is a suit wherein the title is being relied upon by a unregistered giftee. We totally the claim that the petitioner in person was in possession from 2001, and it is only in 2022 that we have disposed, that we categorically deny. That is for the learned trial court to decide, not in the greatest respect, not matter in the divisional jurisdiction. So it is under such conditions how the civil judge senior division has dealt with his lordship will find from 36 is the order, from 41 is the findings.
Yes.
Paragraph 21 onwards. The plain clearly mentions the defendant has forcibly dispossessed him from the suit land by erecting, construction, installing iron gate. The existence of the boundary wall on two sides with an iron gate is also mentioned in the report submitted by the OCPS member. The plaintiff was stated that he came to know of the trespass into his land, which is why he filed a FIR and subsequent complaint to the SP East Siang district, but no action was taken, thereby compelling him to approach this court. The plaintiff is silent, my lord, kindly note, as to how the plaintiff exercised his possessory rights over the land since the year 2001. This is the trial court that is saying it. The plaintiff is silent. Plaintiff is silent as to how the plaintiff exercised his possessory rights over the land since the year 2001, when the suit land was gifted to him by Raju Ratan, now deceased, till 28/3/2022. The plaintiff is silent. The learned trial court himself says so. When the plaintiff filed by FIR against the defendant, as such, it cannot be said that the plaintiff has a prima facie case in his favor. The plaintiff has made no averments to show he will suffer irreparable loss and injury which cannot be compensated in monetary terms if injunction is not granted, and as to how he will be severely inconvenienced if the injunction is not granted. The plaintiff has relied upon other documents which are Kabang decisions, execution petitions. There is no averment as to how these decisions are in any way connected with the suit land. This is the finding of the trial court, my lord. Taking into
There was a Caban decision also.
yes, whatever it is, the trial court is dealing with it. How it is in his favor and how it is not there in the plain itself. How he will suffer damage, all these things. This is the finding of the learned trial court, my lord, kindly note that. Taking into consideration the facts and circumstances of the case, it is pertinent to take note that though the instance suit, such and such, the plaintiff has prayed for granting permanent injunction by restraining the defendant, his associates, employees, contractors, laborers, such and such, for simple disposition grading on the suit land. The averments made in the plain clearly shows that the plaintiff is claiming the suit land on the basis of gift deed dated such and such, executed by such and such in his favor. He has claimed forcible disposition of at the hands of the respondents who has put the construction on the land. However, in the final relief, the plaintiff has only prayed for relief of permanent injunction to restrain defendant from disturbing him with his possession. He was not in possession. The plaintiff itself was defective. It is appropriate to refer to the judgment of the Honorable Apex Court in the case of such and such, summarize the position in regard to suits for prohibitory injunction is as under. Where a cloud is raised over the plaintiff's title and he does not have possession, a suit for declaration and possession with or without consequent injunction is the remedy. Where the plaintiff's title is not in dispute under the cloud but is out of possession, he has to sue for possession with the consequential injunction. Where there is merely an interference with plaintiff's lawful possession or threat of this possession, it is sufficient to sue for an injunction simpliciter. As a suit for injunction simpliciter is concerned only with possession, normally the issue of title will not be directly and substantially in issue. The prayer for injunction will be decided with reference to the finding on possession. But in cases where de jure possession has been established on the basis of title of property, as in the case of vacant site, the issue of title may directly and substantially arise for consideration. As without a finding thereon, it will not be possible to decide the issue of possession. But the finding on a title cannot be recorded in a suit for injunction unless there are necessary pleadings and appropriate issue regarding either specific or implied as noted in such and such. Where the averments regarding title are absent in a plain and where there is no issue relating to title, the court will not investigate or examine or render a finding on a question of title in a suit for injunction. Even where there are necessary pleadings and issues, if the matter involves complicated questions of facts and law relating to title, the court will relegate the parties to the remedy by way of comprehensive suit for declaration of title instead of deciding the issue in a suit for mere injunction. Where there are necessary pleadings regarding title and appropriate issue, if the matter involved is simple and straightforward, the court may decide upon the issue regarding title even in suit of injunction, but such cases are to be exceptions to the normal rule that the question will be title will not be decided in suit for injunction. So the plain they should actually have been dismissed under 711. 25. In the light of the law laid down, coming in our case in hand, the defendant, while denying the title of plaintiff of the land by virtue of a gift deed, has taken the plea that the suit land is in their private possession, which is under occupational possession. Though the defendant is silent as to how he acquired possession, but the boundary wall, iron gate erected on the suit land, whether legal or illegal, by defendant are prima facie proof of possession over the land. That is the finding. The plaintiff herein is clearly out of possession, and his title over the suit land is also disputed by the defendant, which is why the plaintiff ought to have included the reliefs of declaration, right, title, interest, recovery, such and such. The defendant has questioned the credibility of the gift deed data such and such. The dispute between the parties is also the title of the suit land as such. Without determining the issue of title over the property, it will not be possible to determine the legality, illegality of possession of the defendant. The gift deed does not automatically confer right, title, when the gift deed is disputed by the defendant. In addition to that, the plaintiff is not in possession. This court cannot adjudicate on title such and such and such. 28. The interim relief of temporary injunction cannot be granted to the plaintiff because he is not in possession of the suit land. There is no evidence made in the plaintiff so he exercised ownership rights over the suit land from the year 2001 till 2002 when such and such or transfer. My lord, has seen paragraph 28.
My lord, injunction order has not been passed.
Yes,
The civil judge senior division passed status quo order.
Let me complete. My lord, has seen the finding at paragraph 28.
yes, yes.
Injunction cannot be granted. But and what does my learned friend mean by status quo orders only injunction has not been granted? Is the trial court supposed to pass an order that he cannot pass? The application was under order 39 rule 1.
While observing that the interim relief
Yes.
of temporary injunction cannot be granted to the
Yes.
plaintiff.
He passed an order of status quo. That is why we went on appeal. How can an order of status quo be passed when the learned trial court itself comes to a conclusion that an order of injunction cannot be passed? That the plaintiff has not made out any case for passing an order of injunction.
But then there is an order.
Yes. That is why we went on appeal. That is why it was modified.
Supposing.
Yes.
The title is disputed.
Yes.
Now he is claiming on the basis of the gift deed.
Yes.
Claiming that the land belong to him. Do you have any document?
That will be decided by the trial court, madam.
Okay,
We are
but then,
in
but in the
27 now.
meantime, supposing if the construction goes on, then you are creating some asset. If the title
Oh.
is decided in his favor,
Yes, that will be
Then
my
that-
law.
hmm,
That will be my law.
you heard him.
That is my law.
If the title is decided in your favor,
Naturally.
My lord,
naturally it
in
becomes
constructing the
yours.
building, he
Hmm.
is digging,
So
altering.
that is
So
why.
I'm suffering
See,
irreparable.
He is
loss,
taking
my lord.
risk.
No, he
It will
cannot
be
take
at his
any-
favor.
anything.
The thing is,
Hmm.
the only issue for determination here is
Hmm.
whether the district judge was right in modifying the interim order passed by the learned civil judge senior division on the facts of the case, because the learned civil judge senior division himself
I
came to a finding
Okay.
at paragraph 28 that the injunction could not have been granted. That is why by the first appellate court modified the order. How can the civil judge senior division, after coming to a finding at paragraph 28, But
This is,
order
this
of
is,
status.
this is contrary, it
Yes.
appears. Hmm.
so naturally we are confined only to that matter.
While the finding is against,
Yes,
but then granted, of course. that
exactly. And it is on that ground, the first appellate court modified the order of the civil judge senior division.
Hmm.
What is wrong with it, madam? This is a 227 jurisdiction. Was the civil judge, district judge without jurisdiction to pass that order? In my humble submission, no. This honorable court at the revision stage can only look into the extent of the jurisdiction matters. Whether his gift deed is valid, whether he was in possession or I was in
See,
possession.
see, the it is clearly directed that he will not create any third party
Yes.
rights. So that is enough, it appears.
Enough. That is enough. If at all somebody comes on appeal, it should be asked.
Yeah, that is a trial court order, my lord.
Yes, yes.
It's a trial court order.
Now,
Trial
the
court-
appellate court's order is at page 16.
Now,
So it is on that ground. The appellate court has came to the finding that the trial court has came to the finding the injunction could not be granted, but has ordered status quo. That is why he has modified it. Follow to me. Follow. Is your lordship got page 16, my lord, the appellate order?
yes,
From page 18 onwards. The first appellate court quotes the paragraph of the order passed by the Rajasthan civil judge
Okay.
that I was pointing out, my lords.
Mhm.
Paragraph 21 I read, paragraph 26 I read, 28, my lord, at page 19.
okay.
Last paragraph, last line, your lordship will see. Contrary to such findings, the learned court has gone to issue status quo order. That is why, my lord, it was modified. We are not a customary court, my lord. The learned trial court is bound by the CPC. An application was order 39, rule 1. It comes to a categorical finding, and my lord will not at all interfere at this stage, my lord, because the plaintiff is not here before lordship. He has not annexed it. My written statement is not here.
You have not annexed
Anything, my lord, how
the
can you
plain
lordship
and
pass
the
any order
written
at this
statement
stage?
also.
My lord
Why
will
you have
issue
not
notice
annexed?
at the most, my lord, call for the records. And if your lordships have the constitution, article 227,
Hmm.
my lord will only look into the extent of, my lord, whether the district judge has made any error as regard jurisdiction or anything patent on the face of the record.
Hmm.
That not being there, my lord, under 227, my lord, no, there are limits, my lord.
Okay, we'll call for the
My lord
record.
will issue notice and call for the record.
We'll issue notice. Okay.
My lord, in fact, I can produce records, but that is not how it is, that is 227 application. Otherwise, I can show affidavit saying that the donor has not given the land. This is a disputed question. This will be decided by the trial court, not
Yes.
here, madam.
That is quite good. Get out. Had Mr. Lincoln Party. The petitioner in person. I've also had Mr. Deepang, Land Council appearing on behalf of the respondent, Caveator. This petition under Article 227 of the Constitution of India is directed against the order dated District Judge Order 8-1, 2026, passed by the District Judge in interlocutory application number 31, 2025, in Miss Appeal number 05, 2025. Seeking stay of setting. Just a minute. Whereby the or whereby the order dated the order passed by the Civil Judge Senior Division on
4/6/2022.
4/6/2025 in
Miscellaneous case
I
number
may-
97 of
And miscellaneous case number 97 for 2023. Directing both the parties to restrain from creating any. No. Directing the respondent from restraining the respondent from raising any first construction on the suit has been stayed. Why stayed? Huh? There has been stayed.
Yes. It is in modified manner.
Okay, while
Modified with the caveat that the shall not dispose of the suit land. The petitioner is protected.
yes,
Page 20.
where is the operative portion of
Page
it?
20.
Page 20.
Therefore, I am not inclined in favor of the state amendment of the in view of the above, the present IA is partly allowed and the operation of the order that is state to the extent as indicated above. As a consequence, the application is
Where is the operative portion?
second, last two paragraph number. In view of the above, has a pilot word. Page 20.
Yes, sir.
The present IA is partly allowed to the operation and the operation of the state to the extent as indicated above.
It does not-
As a consequence, however, the
Okay, whereby the Line District Judge has partly allowed the IA. Okay, permit. Just a minute. Huh? Keep the earlier one. Huh? And then while however, directed the respondent not to dispose of the suit land during the pendency of the suit. Stop. Huh? Stop. Issue notice. Since Mr. In issue notice, call for a trial code record. Scan copy of the trial is going on.
Yes.
Scan copy of the trial code record. Issue notice. Since Mr. Panya, Line Council appeared and accepted notice on behalf of the respondent caveator, no formal notice will be issued. With this issue stops. This is matter after 4 weeks.
I'll be traveling to Delhi.
Okay, then when you'll come, you are coming back?
I'll be coming by March.
March. Then we'll get it listed during March, second week, third week,
Yes.
second week.
That's fine.
Is prayed for by the council for the petition. List this matter again on third week of March.
I said,
So, but that stands, that you'll not dispose of.
yeah, that
Hmm,
will stay. Matter is not staying out.
okay.
They will automatically stay. Item number 2 of the same order.
My lord, I also filed an IA number C4 2026.
Upon hearing the parties and on perusal of the petitions and then petitions. It is provided that the respondent shall not dispose of the suit land or create any third party interest during the third party interest However, it is not clear that the this code is not, is not passing any order on the order against the raising of. No, will not say that. also.
My lord,
Will not-
this
not-
will
not-
already remain.
That
This
much
will
is
remain.
enough, I think. Okay.
Is my lord not staying the order dated 8/1, it will remain.
Those, so because,
No di-
I'm
no-
repeating
Hmm.
that you are not, you
Yeah.
will not dispose of.
Yes.
Hmm.
Even that was not required because it's already there.
It is already there, of course. Okay.
Notice in the IA also same order.
My lord, I file an IA.
Okay, I also
I-
notice same,
IA, my lord,
because you have not
Uh,
annexed all those,
civil judge,
yes, yes.
senior division has said
Hmm.
that the respondent is
The-
silent
Yes.
on the capacity of his position over a suit lab. They don't have any ownership documents.
Hmm.
And the learned district judge.
We'll
so-
see the record, we'll see the
so
record.
Till,
Hmm.
Your Honor, till such returns a call,
Hmm.
the impugned order passed by the learned district judge be stayed, my lord.
No.
My lord has already declined that.
So, the interim prayer shall we consider on the next date of listing, okay? After receiving the records, okay?
Same order in,
Same order in IA also.
item 2 also.
Item two,
Oh,
a
item two.
similar case,
Okay,
same order by both the.
The only
lower
respondents
court.
are different.
okay,
I have
okay,
instructions to appear on behalf of the respondent.
okay, similar order.
Only my lord may not say a caveat.
Here also, Kevin,
No caveat. My lord may say I am appearing on instructions.
okay,
I'll find my wakalanama to do.
okay, then in that case. Then the respondent, you will only say that Mr. Deepang, Learning Council, on instruction, put appeared.
Yeah.
Okay. Oh,
All right.
Item number 5.
But this is a criminal appeal, my lord.
yes,
This year has been received, my lord. This matter, my lord, paper book may be required
okay. Well,
and matter may be fixed.
then
for
we'll
hearing,
direct for preparing of, paper book,
And matter may be fixed for hearing.
private respondent, any involved,
No, my lord.
is no private respondent.
Private. Fine.
No, there is a private respondent also.
Respondent,
Who is this?
maybe the complaint.
Convicted of, for offense, what offense?
Maybe the respondent. Allegedly setting fire to the house.
Okay. But then there is a private respondent, you have included, it appears. So, whether the private respondents are appearing,
He not appeared.
this, setting the house of the private respondent.
Private respondent complaint.
Okay. Now, since you have implemented, his appearance would be necessary. Okay. Heard Mr. Arsona, Learning Council for the appellants. Also heard Mr. Loy, Learned People for the state. The service of notice upon the respondent number 2 is still awaited. However, the trial court record has been received. The, okay. The registry is directed to prepare a paper book and furnished a copy each to the parties appearing on behalf of And to the counsel appearing on behalf of the respective parties. Starting. So in the meantime, probably he also will come and appear. Or you want to take fresh steps in the meantime? Because paper book will take some around, not less than 4 weeks. Okay, in the meantime, the appellant shall take fresh steps upon the private respondent, number 2, by speed post as well as by usual process within 3 days from today. Starting. List this matter after preparation of the paper book. Okay.
Matter number 7.
Your the legal aid counsel not turn up. Not appearing. Yes. Lordship, on the last 2 occasions also, this or was not appeared, so another legal counsel was appointed, Lordship. This was appointed by the court? Yes, Lordship. Okay. Whether his name is there? Okay, D. Sora. Yes. He is not appearing. What is the punishment? Sentence?
Punishment, Lordship, 304 for part of
How many years? 10 years?
10 years, Lordship.
Okay. No, why he is not appearing? Has been appointed.
As per my record, Lordship, on 10/11/2025, Lordship.
It was appointed on 10/11 only. Thereafter, today only, this matter has been listed.
Yes, Lordship. The name of the Lordship, Nani Madam may be reflected, Lordship, as per the record, Lordship.
Hmm?
On 10/11/25, Lordship, another legal counsel was appointed, Lordship. But her name was not reflected in the cause list, Lordship. Sir.
No, it's Domin Sora only. It's Domin Sora. Domin Sora is legal aid counsel.
Yes, Lordship.
His name has also been reflected in the cause list. D. Sora. We'll give one more chance or what?
Yes, sir.
This Sora is there. Serial number 10. Okay. Probably the legal aid counsel may have to file formal appeal memo.
Lordship, memo was preferred, Lordship.
Prepared.
Yes.
Okay. It's not a jail appeal.
Yes, jail appeal, Lordship.
Okay, then who prepared? Legal aid counsel, must be legal aid counsel only.
Yes, Lord. Put na kami. File पे
This is from jail, straight away, came prepared.
memo prepared lordship.
Mm-hmm.
But
Okay, then record also received with the PS. Okay, hard Mr. Dilo, Lanet PP, for a state, none appears on behalf of the appellant. Although,
figure me.
Mr. D. Sora was appointed as Lanet delegated counsel to represent the appellant stroke convict staff. The record shows that the trial court record seems to have been received. In view of the above, the registry is directed to prepare paper book. Staff. So what we'll do, one more chance can be given to this legal aid counsel,
Yes, lordship.
and then on the next date, if he doesn't appear, we'll
Another-
appoint another legal aid counsel, and by then the paper book also will be ready.
Yes.
Okay,
Yes, lordship.
list this matter after preparing paper book. Okay.
Definitely.
Item number 8.
It is also a my lord, jail appeal.
Yeah.
And here there is no memo of appeal in there.
Then here in that case, then we'll appoint.
My lord, what my humble prayer will be, my lord, may kindly call for the TCR first, my lord.
Okay.
And after receipt of the TCR, my lord, legal aid counsel may be appointed and they will prepare the proper, my lord, the memo of appeal and delay other applications. ma'am.
Mr. TF, then additional PP for the state staff. This is jail appeal filed by the convict Rohan Thami through the jail superintendent.
Yes,
The-
to jail superintendent.
through the deputy superintendent of jail against the conviction against the judgment dated 4/6/2025 and sentence dated order dated 5/6/2025. Passed by the special judge Poxo Teju in Poxo case number 10.
Item number 9 and 10.
May it please your lordship.
Yes.
My lord, service is not completed, my lord. That's why the official office not, my lord.
Okay. Two, still awaited. Conviction. Two, a private respondent.
Yes, my lord.
Conviction under Poxo.
No, my lord, it's not POXO. However, my lord, it's
Third party.
it's under section 460, 326, 323, 427.
Okay.
And moreover, my lord, the synthesis has been suspended by this honorable court.
Okay.
So now paperwork, everything is prepared, but my lord, for ends of justice, my lord, and to give an opportunity to the victim as well as the complainant side, my lord, the notice has been issued by this court in light of the Jagdish Singh matter, my lord.
Okay.
So my lord, let this matter be listed after 3 weeks for awaiting the service report. In the meantime, my lord, I will inform the other side also because perhaps in many occasions the petitioner side was absent,
Mhm.
remain absent. So if the service is not completed, my lord, this court may direct them on later part to take fresh steps again, my lord.
Petitioner is privately engaged.
Yes, my lord. This is not a jail appeal, my lord.
Okay. None appears on behalf of the appellant, however, Mr. Yedullah additional PP is present. Staff. The office not reflect that the service of notice upon the respondent number 2 is still awaited. In view of the above, let this matter be listed after 3 weeks.
3 weeks, my lord.
3 weeks. Okay.
Same order in both the cases, my lord.
Yeah, no, sir.
Yes, my lord.
Okay.
Same arising out of same FIR, same conviction.
Okay. Similar order.
Yes, ma'am. Obliged, ma'am.
Item number 11.
May please, Lordship.
Yeah.
Lordship, we have been instructed by the appellant that he wishes to withdraw this matter, Lordship, for the reason that he has already served the entire sentence,
Okay.
and therefore he no longer wishes to pursue this matter, Lordship.
Release also.
Yes, he has already been released.
Okay.
My lord, they may be allowed to withdraw not on the ground of being infructuous because the conviction will remain there. But since they don't want to pursue the matter, my lord, on the instruction of the accused, my lord,
He has already been released.
Yes, he has been released.
Okay.
the slur will all remain there, my lord.
Heard Mr. Ibrahim, Land Council for the applicant. And Mr. Pierre, Land, there is some PP for the state staff. Mr. Perang, Land Council for the applicant submits. They inform this court that after completion of the sentence, the accused has already been released on there, released.
He has been released, Lordship.
Released. And this criminal appeal has become infructuous.
No, not infructuous, my lord.
Appeal filed by him only.
Yes, my lord, but still, my lord, the conviction will remain there.
That will remain.
Yes.
After completion.
After completion, my lord, after completion also they can challenge the conviction because that slur of the convicted person, but that conviction will remain there. Now, if they don't want to pursue it, my lord, then my lord, simply on that aspect, my lord may record that the accused don't want to pursue this matter on that.
And in view of that, the appellant do not want to pursue the matter.
Yes, ma'am.
Further. Okay. In view of the above, and this criminal appeal is dismissed for dismissed on not being test.
Yes, sir. Deeply obliged.
Lordship, connected IS there, Lordship.
Okay. In view of the order passed in the main appeal, the IA so stands disposal. Okay, dismissed, huh?
Yes, ma'am.
Item number 14.
Deeply obliged. ma'am.
Your Lordship, I'm for the petitioner.
Okay. Who was to file affidavit in opposition?
Private respondent number
Have you
2
filed?
and 3.
Not yet filed.
3 has filed.
I have filed my affidavit, Your Lordship.
Okay. Respondent number, and
I'm-
2, what about 2?
To not file. I'm for the
Are you filing? Not filing, it is not necessary. Not necessary? Yes. Then probably, it was you probably who prayed.
Your Lordship, in that case, matter may be fixed for admission hearing.
Okay. Hardly,
Right.
and also for the petition. Stop. How many responding to? Three. Three. Also hard miss. Lakshmi, Lane, additional PP for the state respondent and Miss
Kinyora,
come out. Semicolon, Miss Seniora, Lane Council
for responding number 3.
for respondent number 3. Who submits that she has filed affidavit in opposition staff, Mr. Proceed. Proceed, Lane Council appearing on behalf of the respondent number 2. Who is also present and submits that the respondent number 2 is not filing any affidavit in opposition. Petitioner was to file an interlocutory application for striking of the name of the respondent number 2 also. Yes.
Your Lordship, for that, let the respondent number 2 remain.
Okay.
They will decide after hearing.
The trial court record has been received. Stop. Since the parties are really represented and the trial court record has also been received. Let this matter be listed for admission after 3 weeks. Okay.
Your Lordship, there is the interim that may be continued.
Interim order passed earlier will continue till the next date of listing. Okay.
Duly.
Item number 15.
May I please, my lord?
Yes.
My lord, this criminal revision is filing for revision of impugn order dated 6/3/25, passed by the Larned District Session Court, UP. Private respondent number 2 to 60 must appear by Larned Counsel, Mr. D. Lagi.
So did 2, 7, 10 to 11, 10 and 11 not yet received.
Service isn't over yet.
Hmm?
The service isn't over yet.
You are for?
I'm for the respondent number 3, 4, 5, 6, 8, 9, 12, 13, 14, 15, 16.
3, 4, 5, 6.
Yeah, 8, 9, 12, 13, 14, 15, 16.
Who else remains then?
So 1, 2, 7, 10, and 11.
In the trial court, my lord, in the trial court, all the accused, this respondent accusers appear by Larned Counsel D. Lagi. In the trial court.
1, 2, 7,
Two-
10 and 11. Yes, of course. 5. No, 1 is the state only.
One is the state, my lord.
Hmm.
2 to 16. 2 to 16 was appeared by the Larned Counsel, Mr. D. Lagi, in the trial court.
No, Diraji appeared here before this court, ever. Whether earlier he appeared.
Yes, filed wakalatnama on behalf of,
But his name has not been reflected in the court list also.
costless, his name is reflected, my lord.
Where? Okay, this is item 15, sorry. Okay. He's not appearing. He is on behalf of respondent number 2, 7, 10, 11.
Yes.
He represents whom? Which respondent?
Duology is for 3, 4, 5, 6, 8, 9, 12, 13, 14,
Okay.
15, and 16.
No, no, I'm talking about 2, 7, 10, and 11.
Oh, there, no one is
You are
appearing.
appearing on behalf of Dilaji.
He's on behalf of Duology also.
Yes, yes. Then my,
Other respondent
no,
parties
no,
not
other
appearing.
respondent 2, 7, 10, and 11.
They are
Who are
not
they?
appearing.
What to do with this? You want to take fresh steps or?
My lord, if they are not appearing by the council, so I have to take fresh steps of the respondent number 2, 7, 10, and 11.
Fresh step?
Yes.
Okay.
Left no any option, my lord, unless they present the before it goes, so hearing cannot be conducted. LCR was called for in the last occasion, my lord.
Trial court records.
TCR was.
Okay, we have received. Hard, Mr. Rama. Lani counsel for the and Ramadan counsel for the petitioner. Ms. El Hajat, Lanet, additional PP for the state respondent. And Mr.
CP Mangla.
Lanet counsel appearing on behalf of, your name is also there? No. Okay, appearing on behalf of Mr. Dilaji, Lanet counsel for respondent number 3, 4, 5, 6, 8, 9, 10, 13, and 14. Start. The office note dated 7/2/2026 reflect that the notice upon the respondent number 2, 7, 10, and 11 are still awaited. In view of the above, Mr. Rama, Land Council for the petitioner prays for allowing him to take fresh steps upon the said respondents. The prayer is allowed. Steps within steps by speed post as well as by user process within how many days?
My lord, within a week.
Within a week from today. So at least this matter after 3 weeks.
My lord.
It is also noticed that the trial court report has been received. Huh? Okay.
Okay.
Much.
Item number 16.
My first lordship,
Hmm.
on 2/09/2025, a victim notice was issued, but no one representing lordship. So LSC may be appointed.
Who is legal aid counsel? Morik Bagra.
Yes, lordship. There is a lordship list of amicus curiae, lordship. Amicus may be appointed, lordship.
No, Morik Bagra is there.
Yes, lordship. But today he is
is
not
that?
appearing.
POCSO?
Yes, POCSO, lordship, under section 6, lordship.
Records, we have received the record.
Yes, lordship.
Okay, what we'll do?
And memo is also not there. Memorandum.
There is no memo.
Yes, yes, lordship.
Whether there was any delay in filing the appeal?
Lords, since there is no IA, lordship.
No, just
IA.
when the judgment was passed. Judgment was passed in 2000. Yes. Judgment was passed way back in the year 2016. And an appeal filed only this year. There probably. Naturally, there is a delay.
Yes, lordship.
Okay. or Mr. Dilo, Learned Public Prosecutor for the state. So no one appear on behalf of the appellant staff. Sorry. The Learned Legal Aid Council for the appellant is not present, although his name has been reflected in the course list. Mm. No, it will be difficult. Then earlier also only on 28/11 also, the Legal Aid Council remain absent.
Yes, Lordship.
So what do we do?
Appoint another LAC, Lordship.
Any Legal Aid Council present?
There is a lead.
Who is present today? Yes, right. Okay, what is this? Okay. Marcus, after preparation of paper book. Kanina Ramali, who kindly volunteer, who is present, Legal Aid Council for the High Court? Anyone present? Kani Maling, Vidarang, Doju, Lamnio, Nochi, Jerami, Jeram.
No one is there, Lordship.
Okay. So not interested, all of them. Then I think we need to change. This.
Lordship, Gaken Jini may be appointed, Lordship. Gaken Jini may be appointed, Lordship.
Jinu.
Yes, Lordship.
He is present?
No, not.
No, supposing if you remain absent then? We'll have to,
He is regularly appearing.
but we have to ask him. In their absence, if we appoint, I think they take it very lightly.
Then,
Have to
Lordship,
ensure that they are appearing.
Lordship, then this matter may be passed over for a while, Lordship, so that I can.
He's in the court today.
I will tell Pinaki ask him, Lordship.
Okay, because earlier we have already appointed. Then in that case, just the trial court record has been received, staff, the registry shall prepare. No, first of all, there is no memo of appeal also.
Yes, Lordship.
Then I think memo of appeal required to be prepared first. So that the paper book is prepared. However, in absence of the Legal Aid Council, you want to wait for some time?
Yes, Lordship, so that I can confirm that whether he will appear or not.
Punishment is for how many days? How many years?
Lordship. 10 years, Lordship.
Okay, 10 years.
Oh, no, sorry.
I think.
No, sorry, Lordship. It's POCSO section 6, it's 20 years, Lordship.
No, not 20. 20 cannot come in a single bench, before single bench. Then you see.
Lordship, sorry, Lordship, let me confirm, Lordship.
It's 10 years.
Yes, Lord, 10 years, Lord. 10 years,
Then
Lordship.
the record see the record that the judgment was passed on
506 IPCN 80 section 8 of POCSO Act, wherein the accused was acquitted, my lord, by the special court.
Okay.
And the
Is there
victim,
any delay here?
no, my lord, this matter has been admitted, no delay, my lord.
Okay, admitted.
Yes, my lord.
Then since we have received paper book, sorry, the trial court record, we can direct for preparation.
Yes, my lord, and the expenses has to be bear by the
By the
appellant.
petitioner.
Yes, lord. That can be done, man.
Okay. None appears on behalf of the appellant, however. Mr. T. A. Pradhan, addition PP, is present, staff. The trial court record. No, what about the?
My lord, whether the acquitted person had appeared while any wakalatnama or
No, this is just for the second time it has been listed, probably.
Here, because the acquitted person is the necessary party, my lord.
Respondent number two appeared. Okay. File Wakalatnama, name not reflected, it appears. So that is why.
And my lord, in order that may be reflected that the
Yeah.
Wakalatnama filed by the,
Let us confirm.
yes, ma'am.
In the office note, it is there.
Perhaps it's by listing L per me, my lord, perhaps, my lord.
Yes, yes. El Perme, correspondent number two.
Yes.
Just a minute, huh?
In office note, my lord, it is reflected.
No, how many respondent? Only.
Only one, my lord.
Okay.
Respond number two, Kitan.
Although Mr. El Parme would appeared on behalf of the respondent number two by filing Wakalatnama. However, his name has not been reflected in the course list. He is not present today. In view, it is also seen that the trial court report has been received. In view of the above, the registry is directed to prepare a paper book, furnish copy each to the Learned Counsel appearing on behalf of the parties, staff. Paper book at the cost of the
Appellant,
at
my
the
lord.
expense of the appellant. No, not furnish, then at the expense of the appellant staff. The registry is also directed to reflect the name of name of Mr. El Parme, as counsel for the respondent number two staff. List is matter after
My lord, 3 weeks.
preparation of paperwork.
3 weeks.
3 weeks, probably they will not,
4 weeks, my lord.
after 4 weeks.
4 weeks.
Okay. Yes.
Item number
Like-
18 and 19.
May I please, Your Honor?
Yes.
Your Honor, I am appearing for the petitioner on behalf of Mr. T Tang. He is out of his station, so I am seeking adjournment for today. Matter may taken after 2 weeks, ma'am.
Objection not yet filed appears. Respondent has not yet filed any objection. We wanted to file objection. Are you filing? Who is for the respondent?
I am appearing for 18 months.
I'm for the respondent, my lord. Respondent, are you filing objection? No.
This is item 18. Yes,
Yes.
this is for item 18.
Item number 18 and 19 are connected matter. Impleaded. They have already impleaded. No, impleaded, that is what they say. They wanted to file objection. I'm asking whether.
In item number
Not yet filed.
19, my lord, I am appearing for respondent number 16.
No, in 18. This is 17. Why is 17?
No, my lord, 18.
18 and 19. My lord, 18 and 19 are connected matters.
Sure.
the respondent appearing on behalf of Mr. Esther. Why it is 17?
I think 19.
19?
It's never 55, I think.
Which one is 18? Okay. This 52.
My lord, here 18. Already, my lord, this in item 18, they have filed for implement. And already this court has allowed the implement petition, and we have already amended the petition. That is item number in item 19.
No, just don't mix. What is 18? Let us see the 18. 18 whether the council appears for the respondent.
No, my lord. Yeah. On behalf of.
You are for respondent. Come to your side.
Oh, no, no, in 19.
Respondent. Come to respondent side. You come to your side. Don't confuse the court.
No.
You should all know your place. Okay. Wait. You are for the petitioner in item 18.
Yes, Your Honor.
Okay. So Just a minute, with Mr. Prasad. How many respondents are there in item 18?
Item number 18.
Sole respondent. So you are appearing. Are you filing any affidavit?
No, my lord, here, I think implement, my lord, already did the.
Implement?
Yeah.
No.
Yes, sir, depend.
Is there is IA also?
No, I am not here. Item 18. My name is.
No. You are appearing in which item?
The item 19.
19?
19.
Okay. Take your seat then. Who is in
I'm
18?
appearing on behalf of Mr. Esther,
Esther.
court respondent. So, my lord, due to some domestic problems, leading counsel could not appear today, so
Okay, he filed otherwise. Earlier he appeared.
The respondent in the item number is not yet appeared, my lord.
Hmm?
In item number 18, my lord, the respondent is not yet appeared.
18 not yet appear. Okay,
Yes.
you are appearing for the first time, Lani Council, on behalf of Mr. Tai.
yes, my lord.
Tai is appearing. Have you filed wakalat nama?
No, my lord. I'm appearing on his behalf.
Okay. What is your instruction? Whether he's told you that he is filing wakalat nama? Whether he instructed that you are, he is filing wakalat nama? There is no wakalat nama,
Not yet filed, my lord.
not yet filed.
Yes.
Okay, you are his associate.
Yes, my
Okay. Okay, you took a step by dusty way. They have received, it appears, since they are appearing.
Yes, maybe.
Okay. But then you have not yet filed affidavit also, that compliance affidavit.
Yes, your honor. I
So
have instructed to take
are you appearing in, you are appearing on behalf of
tea time.
Tai? No, just Mr. Tai is appearing on behalf of Anong Tai. Do you know that?
Yes, my lord.
Okay. Yes. Mr.
M. Doziman,
The Lani Council for the
petitioner on behalf of tea time.
petitioner appearing on behalf of Mr. T. Tai. Staff. Mr.
K. Kirkom.
K.
K. Kirkom. Appearing on behalf of Mr. Esther.
Okay, submit that. He has an instruction that Mr. S. Tai
Yes, my lord.
would be appearing in this case on behalf of the sole respondent and prays for some time to file wakalatnama. The prayer is allowed. It's one time. The prayer is allowed. List is matter after 3 weeks.
After 2 weeks, my lord.
After 2 weeks, okay. Tell him that within 1 week he has to file. He should file his wakalatnama. Lani Council. Tell your senior that he have to file wakalatnama within 1 week. Okay. Okay, then next is you.
Yeah, item number 19, my lord.
I
I
am
am
petitioner.
You are petitioner.
Yeah, yes, in item 19.
You said that you are for respondent. Now how?
No, in 19, and I was confused in that.
But in the 18 also you are not respondent in 19.
No, I am here petitioner.
19 for the petitioner.
Yes, ma'am.
Okay, I thought.
My lord, the record was not called for. The record may be called for. And
In the earlier case, where the record was necessary, call for.
no, my lord, my lord, this is the case of
How it has come together? It's a similar case.
not similar, exactly similar,
No,
but,
not name also different.
but respondent are same. Respondent,
Respondent are same.
Anong Tang and others.
Anong Tang.
And in 18 also Anong Tang and others.
But then
in item number 19, my lord. I was not made as party, so I had filed IA and accordingly I have been implemented in this.
simply that.
Yes.
Reply finally.
What is left?
Now I am appearing for respondent number
Where
sixteen in item number 19, my lord.
Steps. Where is the IA?
I have been already included.
Already, my lord, the IA was already allowed, and we have amend the petition, and he is the respondent number 16. Respondent number
This is
16
the
now.
amended petition.
Yes, he is respondent number 16 now.
Dispose, just a minute, huh?
Yes, 16, my lord.
Just a minute.
My lord, I'm for the respondent in item number 19. Appearing on behalf of Mr. Esther, due to some domestic problems, legal counsel could not appear today. So I need some more time.
Huh. Alok Tang is
Petitioner.
petitioner here.
Yes,
So there are how many respondents?
16.
16 respondents.
16. And the 16, serial number 16 is newly impleted.
16 newly included.
Yes.
Although not reported. Huh? Anyway. So. Mr.
Titak.
Titak, land counsel for the petitioner. You have for respondent number
I am for the respondent number 16.
or newly implemented,
Yes.
and you have for respondent number all. Okay. So his name not reflected. No, Orin Modi, Esta is also there. Okay. Okay, already there. So. Mr. Land Council appearing on behalf of Mr. Esta, Land Council for the respondent number 1 to 15. Praise for. You were to file objection. Praise for some more time to file objection. Praise for further 2 weeks time to file objection. And what about you, respondent number 16? Are you filing objection?
My lord, I will take instruction for them.
Okay, Mr. Mr.
M. Doji, my lord.
M. Doje. Doje, your name is not there.
My lord, in here also I am appearing on behalf of Tea Time.
Some who appear on behalf of Mr.
Tea Time.
Land Council for Time.
Yes, my lord.
Land Council for the respondent newly implemented respondent number 16. Land Council for the newly implemented respondent number 16. That means that we need to. You are appearing for the first time. Oh, Land Council is very. It will be difficult. You should know your case, huh? For whom you are appearing? What is the stage? Some is that we need to obtain some an instruction from the respondent whether to file objection or not. And pray for one at a time. The prayer allowed. This matter after 2 weeks.
Yes, my lord, this division petition.
Just a minute, huh? It must have code for. The counsel for the parties, allowing counsel for the parties, some is that the trial court or a court would be necessary for proper adjudication of this case. So, in view of the above, submission, comma, and accordingly, the trial court, let a trial court record be called for. Scan copy, trial court is disposed of or still pending? Disposed. Disposed. Maybe.
Deputy Commissioner Pasigat.
Okay. For the trial court record. List this matter after. Then in that case, it will be listed only after 3 weeks.
Yes, sir.
Okay, list this matter after 3 weeks. Okay.
All right.
Item number 20 and 21.
Lordship, I have, said in my application, there is no detail, any no prayer for interim order, so, I'm seeking interim order, so, matter may be admitted, fixed for admission hearing, and, I may be allowed to file interlocutory application for interim prayer. in this case.
My lord, otherwise this matter is not maintainable at all. Why? Because, you know, my lord, this BNSS, after this enactment of BNSS, now there is a sudden procedural change. Now, before taking cognizance by the court, notice first has to be issued to the accused before taking cognizance. Then cognizance has to be taken after hearing the accused only. Now, magistrate cannot directly take the cognizance like earlier days in the CRPs. Now, here the case, what is the order that is being put into challenge, my lord? Is the order issuing notice? Why this notice was issued? Just to enable him to appear before the court and argue that whether cognizance should be taken or not. So how that giving opportunity, you come and you show your defense whether cognizance has to be taken or not. That has been put into check. This is basically interlocutory order. This cannot be challenged. This is only BNSS, my lord, because now what is the content?
Where is the impugned order? Just
Yes, yes. May I take page number 32?
there is 32 page also.
Page number 32.
32.
21.
Okay, this is 20. Item 21.
I am in item number 21.
21 is locum talo, el talo. Okay. Item 20 page, same.
Case are different, but
What? The impugned order.
page number 32, my lord, item number 21.
Okay, it's akin to item page 19.
32.
Same order.
No, not same order, my lord.
Okay,
Page number 32 of item number 21,
21, 32.
my lord.
Yes. Same order.
32. My lord, this is just the notice on,
Yes, record pura.
nothing.
It's appearance only.
Yes, my lord. Now, may I take, my lord, section 223 of the BNSS? Earlier, first cognizance has to be taken, then only notice had to be issued.
This is a complaint case.
Complaint case, defamation. Now procedure is changed. Section
Now,
223.
this probably was the first appearance for
After BNSS.
first appearance only.
Yes,
No.
yes, first appearance. Before, my lord, cognizance cannot be taken
Yes.
now.
Yes.
But now, earlier what happened that without giving opportunity,
Hmm.
cognizance used to be taken. So these changes
It has to be in
brought by
presence of the respondent or.
BNSS.
Okay.
Section 223, proviso.
It's examination of complainant, 220.
223.
Yes.
May I read, you know? Examination of complainant. A magistrate having jurisdiction while taking cognizance of an offense on complainant. The word is here, while taking cognizance of an offense. The examination is required when the cognizance is taken of the complainant. Shall examine upon oath the complainant and the witness present, if any, and the substance of such examination shall be reduced to writing and shall be signed by the complainant also. Now, my lord, provided. Now, my lord,
Yes, Major.
proviso.
Complainant and witness present. Shall we examine upon oath
Yes.
the complainant and the witness, but witness also need to be, okay. It's
Yes.
Correct.
I'm sorry,
Any-
now
And the
proviso,
substance of such examination shall be produced in writing. and
Provided.
Signed by the complainant and the witnesses and also the magistrate, okay, provided, yes.
yes, my lord. Now this is very important. No cognizance offense shall be taken by the magistrate without giving the accused an opportunity of being heard. Now,
Now, after examining the complainant only,
no, now examination is for taking cognizance.
no, examination of the complainant.
Now, my lord, here,
Hmm.
is saying that a magistrate having jurisdiction while taking cognizance of an offense. Cognizance cannot be taken. It is the magistrate having, while taking cognizance of an offense, examine. When cognizance is to be taken, then it has to be examined. Now, my lord, what is the purpose of this proviso? This is the proviso that to enable the accused that before taking cognizance, he can put his defense. Whether the case has been made out or not, whether the prima facie case has been made out for taking cognizance or to proceed further on. This is one of the proviso whereby the opportunity is being given to him, saying that whether the case is made it out or not.
Which court is issued?
Judicial magistrate first class.
But then,
Yeah.
see, whether the complainant has been already examined.
No, my lord, because cognizance was not taken. It is this notice was issued before taking cognizance. So what happened when
The notice was issued to whom?
notice to the accused person before taking now two stages are there. Now
Now, this is where 223 is equivalent to 200 earlier.
earlier 200, but this proviso was not there. Earlier there was no requirement of giving notice to the accused. Straightly after examination of the complainant and a witness, the magistrate can issue after taking the complainant. Now there is a slight modification that without taking cognizance, notice has to be first issued.
No, simultaneously on the examiner, on the day when the complainant is examined, cognizance will, the magistrate will not take cognizance. First of all, the magistrate has to examine
Right.
the complainant.
Right.
After satisfying, then before taking cognizance, a notice is to be given. It appears.
The magistrate having
was like that
while
only?
taking cognizance of his commercial exam.
Hmm.
upon the- So here, my lord, my understanding, my lord,
Hmm.
that so far, because ultimately this the opportunity is given to the accused person, so that before cognizance, because cognizance examinations require when cognizance is taken, because cognizance is a different stage.
No, for taking cognizance, only examination is required.
My lord, my lord.
Complaint automatically will be filed, but then on complaint,
My lord.
in order to take cognizance, he has to first examine the
Yes.
complainant.
Yes, for taking cognizance.
Yes.
But this notice is before taking cognizance. My lord, this is something.
Before examination,
Before,
just specific question,
Madam.
is it before examination? Before taking cognizance, I understand, after examination. After examination of the complainant, but before taking cognizance.
that is something where gray area, whether this has to be like, for even issuing the notice, whether the examination has to be done or not.
See, earlier also, under 200
My lord.
CRPC, the magistrate on receipt of the complaint, he will examine
Yes,
the complainant
and witness.
on oath, okay, sign, witness also sign, and then after satisfying that, yes, there is a case.
Yes.
He will take cognizance, of
Yes.
course, maybe without notice.
Yes.
Then he will issue. After taking cognizance, he will issue. But
Yes.
here, it appears that after examination of the complainant and the witnesses, he is satisfied, and but before, he cannot, but even if he is satisfied also, he cannot take cognizance, it appears. Cannot take cognizance unless he issue notice to the accused. After notice, cognizance will be taken after issuing
Now the
notice.
question before my
But
lord,
after examination.
yes, the question before my lord is like
Huh.
that whether without examining the complainant, whether the pre-cognizance stages notice can be issued to the accused or not,
Hmm.
number one.
Hmm.
Because ultimately the purpose is that that before taking cognizance, you give your version of the story. That this is the complaint against you came. Still, because cognizance it is a different stage where the cognizance of the this offense has been taken. So only mere notice is, my lord, as on today, at the till the time when the this order was issued, notice was issued, no cognizance was taken. It was only that you come and you say your part of the version of the story, whether the case should proceed
Okay.
ahead or not, my lord.
Okay. one-
So now, instead of, my lord, appearing before the learned trial court, my lord, that they could have made a submission there that why cognizance should not be taken. They did not appear. And straightly 528, 482 criminal petition has been filed. And, my lord, criminal petition, I think so far notice is concerned, my lord, this is a interlocutory order. And against interlocutory order, my lord, such revision or criminal petition is not maintainable, my lord.
Criminal petition is normal, that is, for you, is it quashing petition?
Yes. Quasi. Quasi, since lordship, criminal, this judicial proceeding has been already initiated against the accused party. Whereas in such nature of cases, the complainant has to give prima facie satisfaction before the magistrate that there is an offense. Offense has been committed by the accused person, but there is no such cases. But it is an abusive process. Without any satisfaction.
My lord, may I pray, my lord, this matter may be fixed for admission, my lord. In the
Yes.
meantime,
Oh, yes, yes.
I will
At
do
least
also
raise
some-
this question.
This is a new,
Right, right.
new provision, my lord.
New edit. Okay,
Yes.
anyway.
Admission
so-
hearing.
Admission hearing, and on that they will try to clarify the law point on this one.
We will try to negotiate the matter. Law point. And in the meantime, I may be allowed to file this interlocutory application since in my petition, there is no prayer portion of the inter prayer. Unfortunately.
So Sunar is appearing for the first time, earlier also already appeared,
My lord, yes.
appears, okay. Okay, after filing work coming. Okay, Mr. Tikapa. Learning counsel for the petitioners. Also hired, also Mr. Sona, learning counsel preparing on behalf. Oh, sorry, Mr. Dilo, PP for the state, and Mr. Sona for the respondent number 2, learning counsel for the respondent number 2. Since the parties are duly represented, let this matter releases for admission after 2 weeks.
After 2 weeks.
In the meantime, I may be allowed to file
The
interlocutory application.
counsel for the petitioner is also at liberty to file interlocutory application seeking stay of the impugned order.
Yes.
Okay.
Matter number 22.
My lord, here, just now I received the IA 193. My lord, then I have to reply this petition, my lord. This is analogous matter, my lord. This is pertaining to condonation, my lord.
Oh, sorry. Which one?
Your Lordship, in item number 22, I'm the petitioner.
You are the petitioner.
Yes, and service report in respect respondent number 3 to 7 is still awaited.
Okay.
Your Lordship may allow to file, to take first step.
Miss.
Lordship, on the last occasion, teacher also called for lordship, but it appears this is
Hey, right.
not present.
Hmm?
TC are not received yet, Lordship.
Oh, it was called for otherwise.
Yes, yes. On
Counsel for
10,
the
11, 25.
petitioner. Also had Mr. Lauren Nanaviti for the state staff. The office not dated 5/2/26, sorry, in view of the office not dated. Just a minute, service. How many respondents altogether? 3 to 7. Who is 2?
Lordship, 2 to 7,
No, it reflects only 2. 2 is separate or different? Who is 2? Respondent number 2.
2 is the informant, Lordship.
Appeared earlier.
No, Lordship.
2 is informant.
2 is Lordship, IO of the case, Lordship. Or sorry, Lordship, Sub-Inspector, Lordship.
Okay. In the record details of the service, upon the respondent number 3 to 7, he is still awaited in view of that the Ms. Railani counsel for the petitioner prays for allowing her to take fresh steps upon the respondent's stop prayer allowed.
Your Lordship, there is an interim.
Hmm?
There is an interim order that may be continued.
Steps for notice upon respondent number 2 also, or from 3 only?
From 3, Lordship.
3 to 7. By a speed post as well as by using process within how many days? Steps?
3 days.
Within 3 days from today. Okay. The trial court record is called for is also not received. The registry is directed to issue reminder for the record. Reminder for the scanned copy of the PCR. Please this matter after 3 weeks. Stop. The interim order passed earlier shall continue till the next year of listing. Okay.
Item number 23.
My lord, here I am appearing for a petitioner, man, appellant.
Hmm.
There are 2 IAs, my lord. That's the 192 is for condonation of delay, and 193 is the substitution.
2 IA.
Yes. IA 192 of 25 and IA 193 of 25.
Okay. Here you don't miss.
Just now I received,
You are for the respondent. Come this side.
My Lord, the
IA is for condonation. Are you filing? Do you have any objection?
yes, 192.
192 they have filed their objection.
But
192 they have filed
Yeah.
already.
in 193, just now I received the copy.
Okay. And 193 is for
193, my lord, is for substitution because
substitution.
yes, my lord. Initially,
You should have no objection.
No, my lord, all, this 193 is pertaining to for the delay cost due to substitution.
Hmm?
That I.
193, my lord, is the substitution because initially this the issue, the dispute was between the father and the son, my lord.
Okay.
The appellant here is the son. Now what happened that Kaba was there and then
The dispute is between father and son.
son, man. And now what happened, my lord, that in the final argument was done, man. And it was reserved. The judgment was reserved for around 3 months, my lord.
Mhm.
And it was delivered in 29/10/2025, my lord. Now, in the meantime, before the delivery of the judgment, my lord, the father expired, man, passed away. Now, what happened, my lord, since as per the Adi custom, my lord, the youngest son is the legal heir otherwise.
Okay.
Now, the appellant is the legal heir. Now, but otherwise, he was also because as per the
Subsequently
custom,
judgment delivered
yes,
against you.
against me. Now, in the meantime, what happened that when before the delivery of the judgment, the father passed away. Now, as per the custom, I am the legal eye. But since the dispute is there, after some thinking, he somehow made a appeal against that order, my lord, of the CJM or
Oh.
Civil Just Senior Division. My lord.
Who filed appeal?
This appellant, my lord, the son, my lord.
But then you said that, you are youngest and then the youngest is the
Yeah.
one who is the legal heir.
Yes, no. No, but
And
since
then
the dispute,
the dispute become infructuous pending before.
of course, my lord, but other brothers are also there. So he filed an appeal
Have they come?
before the district judge.
They appeared.
Then there he made his elder brother said the party, man. Now,
No, elder brother, they voluntarily came or you just made them? Part?
made them party, man. Of course, it was without
then you
knowing
said
the
that
facts also.
It is you
Yes.
who is supposed to inherit?
Yes, man. But since the judgment
But then
is
you
there-
have implemented them.
Yes, man. Now, when that was done, my lord, in the meantime,
No,
they
no,
came
no.
to
The father died before delivery of judgment.
judgment, man.
Whether this was informed to the,
Unfortunately, I don't think it was informed, my lord.
okay, that is why the judgment was against him.
Yes, ma'am.
Thinking that father is still alive.
Yes, ma'am. Now, in the meantime, now the mother of the mother and of the appellant, my lord. Later on, he came to learn that the mother has procured some succession also.
Okay,
In terms, of course, it is with regards to the movable property only.
Yeah.
Now, that's
But-
why, my lord,
uh,
the appellant wants to substitute his mother. Man. That is the why, my lord, the substitution
Okay.
is there.
assuming that mother is now possessing the
Yes, ma'am.
this piece of
Yes.
land. It's under mother's physical possession.
Yes, as of now.
Okay. Then implement, you shouldn't have any problem.
No, why not? This is not a implement.
93,
Yes,
193 is for substitution. Yes.
This is substitution. man.
Sorry, substitution.
Yes.
You have any problem?
No, so in substitution, I have no.
Okay, then let us wait. Then call Mr. D. Sopi, land counsel for the applicant, no, sorry, applicant. No, this is condonation.
IA 193 is for substitution. The
93
two-
is for substitution.
Yes, 192 is for condonation, my lord. 193 is for substitution.
The condonation order is there in 93. Okay, in both. This has been listed for the first time,
No, my lord.
substitution. There is no other.
This has been listed, my lord, for several occasions, my lord, since 1/8/2025, my lord.
Okay, listed along with
Yes.
92. That is why 92 order is there.
Yes, ma'am.
So these all orders are in 92.
Yes,
Yeah.
ma'am.
But they have given today, man. The service copy, man.
Hmm?
Today, just now,
Okay,
they have
okay, but in substitution, you shouldn't,
Yes, yes.
there shouldn't be any problem. Okay. Also had Mr. Itaki, land council appearing on behalf of
Sole respondent.
the sole respondent, staff umpire. No. An application under section 5 only.
No,
93 is also section 5.
no, my lord, 193, yes, my lord. Because otherwise, substitution also, my lord,
Before, there is a delay in substituting also.
yes,
Okay.
delay is also there. Because of the father,
This delay we can condone. How many days? 92 days.
my-
292 days.
This delay, you have any
No,
objection?
no, my lord, in delay, I have to file objection, man. Because there is the huge delay, man.
Okay.
Just now I received the copy that I am not prepared, the 193. They have cleverly given this copy.
no,
Just
no,
now, my lord.
it was
I have to read it.
unintentional because I was
Because-
under the impression that
Because in
copy
this
has been
application,
served.
it was filed that application under section 5 of limitation.
No,
Man,
You want to file objection?
Yes, I will file objection in this case also, man.
Okay.
Now, my lord, this matter may be fixed on another date. The meantime, I will file reply. Because the, in
This is
192,
an application.
well, already I have filed objection. 192.
Filed under section 5 of the Limitation Act 1963. Railway and 1963. Huh? Praying for condonation of delay of 292 days in filing the substitution petition, huh? Issue notice. Since Mr. Taki, Land Council would appear and accepted notice on behalf of the sole respondent. No formal notice need be issued. Mr. Taki prays for who wants to file objection and prays for some time. Prayer allowed. Stop. This matter after 2 weeks. 2 weeks. Okay.
Matter number 27.
Your Lordship,
Yes.
I'm for the respondent. Your Lordship, paper book hasn't been received yet, so may this matter listed for after 2 weeks.
Paper book prepared. Okay. After preparing, which is listed for the first time. Okay.
My lord,
You are for
I'm appearing behalf of my senior member for the petitioner,
okay. Mr.
S.M. Singh.
Land Council S.
M. Singh.
Singh, Land Council. Appear on behalf of Mr. M. Bhatt, Land Council for the appellant. And Mr.
M. Dolian.
M. Dolian, Land Council, appear on behalf of Mr. S. Koyam, Land Council for the respondent. Start. The paper book appears to have been prepared. Have you received the copy of the paper book?
No, no, Lordship.
How many? Part 1, part 2. There is only one copy. And
Yes, Lordship, paper book is not received yet.
not received. I hope there is a copy of the paper book. Okay. It was, registry. It is, it has been prepared at the cost of the expense of the appellant or just a minute. Just a minute. Okay, Pope. Okay. What is the direction? Okay. Council has to pay for the paper book.
Yes, sir.
Appellant. Okay. So, the record reveals that the paper book is ready. Furnish a copy of the paper book at the on payment. of the cost to the parties. Staffa. Since the parties are duly represented and the paperwork is ready, let this matter be listed for
After 2 weeks.
hearing
Yeah, after 2 weeks.
after 2 weeks. Just tell me the substantial portion. Okay, after 2 weeks. Okay.
Much obliged.
You in the meantime, receive the paperwork. Okay. Yeah.
Matter number 28.
Well, this criminal petition,
Okay.
this is for quashing of the FIR,
Mhm.
which I have filed. The challenges here in this petition is both in facts as well as in law. My lord, I say here law means so for the application of 17A of the PC Act. So for
17A of
PC Act,
PC Act.
1988,
Hmm.
Prevention of Corruption Act,
Hmm.
88, that is on law. Now on facts about the locus of the complainant, I first, my lord, I respectfully take my lord to the FIR that my lord will find page 25.
This is for hearing only.
All
What
the
is the
PDs have
reading?
been completed. This is for hearing.
Hmm.
So I'll be taking at least some time,
We have only half an hour.
half an hour.
How much time? 4:15 or 4:30?
I think it will take more than that, madam.
Yes.
Because it will be a lengthy one, I would say.
I can at least highlight so that my friends can answer to that because
What's going on?
You are there tomorrow? No, tomorrow. There will be.
my lord, I have got a matter on 12. So my learned friend is suggesting 13. That can be heard on 13th because
13? Okay.
because as my lord will be hearing on 13,
Hmm.
as we have got another 10 minutes time, my lord, I may just may be allowed to continue
Okay.
because so that we can
Mhm.
sort it. So for this particular complaint is concerned, my lord,
Hmm.
that my lord will find in page 27 of my application.
Mhm.
My lord, it says it's filed by one Mr. Jane,
Hmm.
one Jane, Nabam Jane. So it goes like this, page 27 of my petition.
Hmm.
I'm submitting this FIR against the aforementioned official for demanding a bribe amount of rupees 7 lakhs.
Okay.
Personally, in connection with the work extension of 11 kV, he is given that 11 kV line from Sima to Pote village, including the construction of so and so, so and so. Sir, the first thing, sir, I have participated in the tender using the firm.
Hmm.
He says that he has participated in tender using the firm name,
Hmm.
but the NIT, the participation of the NIT will not show that. So if we go by the golden rule of Bhajanlal, the 7 golden rule, the rule 5, 6, and 7 is totally applicable so far my case is concerned. Because the 7 golden rules of Bhajanlal that my lord knows about that judicial application. Now, he says, sir, I have participated in a tender using the firm AT Enterprise and the work was awarded. Now, who is he? That is the first locus. Who is he? I have completed a project as per the NIT guidelines. But what NIT guidelines says, my lord, that will come into question now. That is what I say about the facts. How your payment has not cleared, despite the payment of the deduction of TDS GST is required in the NIT. The concerned officer, as mentioned here, is demanding a bribe amount of 13% for personal wrongful gain. This is very important. For personal wrongful gain, let's assume for the time being, so for his sentence goes, excluding the required official percentage payment. Now the complainant says 2 things. Apart from his locus, he says, for his personal wrongful gain, excluding the required official percentage payment. What is this? My allegation so far, I am concerned, my lord, posing for the time being, let's assume that is an allegation against me. But the second sentence, excluding the required official percentage payment. So meaning that he is in collusion with paying to other guys also. If it goes by his own complaint, it goes by his own sentence. Now, as per the tender, the second paragraph, as per the tender, the payments should be made to the contractor. Well, it is what he says. However, the authority is delaying the payment and demanding a bribe amount to clear the bill. Mr. So-and-so, executive engineer, Sagali division is harassing me, and my bill payment has been held up with an undertaking under the seal and signature of so-and-so that the payments shall be made after the first LOC BE 2025-6 result. Now, he says that the bill can only be paid after 2025-2026, that LOC BE result, from where the question of again payment will come. The official concern has categorically and specifically said that this payment cannot be done because there's no money, and this can be done only after 25-26 result. That is what is admitted in FIR. Now, if action is not taken promptly, the youth and the general public of the area will continue to suffer. Well, a very social-minded concept. Having witnessed the officer's corrupt practice for years, I have personally faced similar harassment and on multiple occasions, resulting in mental and financial distress as well as increased liabilities. Now he is giving this complaint only in the year 2025 on 7/7/2025. Now next page, my lord. To protect the welfare of the society and to prevent further corruption, I request the officer in charge of the Anti-Corruption Bureau, Itanagar, to book the officer under appropriate sections of Prevention of Corruption Act and BNS so-and-so and alias. Now, what he says, the last part is more interesting. In support of my written complaint, I'm enclosing here with a video footage and photo depicting Sri C negotiating a bribe amount. He is giving a photo for negotiating a bribe amount that he is enclosing in his 7/7 complaint, and says that this officer is of habitual character. Now, the complaint is of 7/7/2025. He is giving some photos. What that negotiation mean? Whether photo can speak. Whether the photo will speak.
It's a still photo.
Still a photo. What photo will reveal it? By giving a photo, somewhere I may be in the marketplace, somewhere I may be, whether that photo will speak about my character. But whereas on other side, the petition says that this particular complaint is known to me. It's known to me, and he has taken us some private loan for me. Private loan.
Any written document?
No, at least on the friendship, and we have good witness, Nothing on document. I'm sincere enough to say that nothing on document. It's all verbal. It's just a matter of 2 lakhs, not much also. So that payment was done. So I insisted him to pay back the other, because it's a friendship thing, which we don't go that on documentation also, which he has totally denied. Now, for that payment, I requested him to pay back. Now the question is, who is he now? Who is he? Whether he is what he says, as per the tender, I have participated in a tender using the other farm. Who is he? He has participated in a tender on what capacity? On the day when the complaint was filed, 17/7, he even could not even say that he is a power of attorney holder of the farm. On 17/7, he says, I have participated in a tender using other farm. At least on the day, he ought to have said that I am the power of attorney holder of the farm. Even though it's allowed or not allowed, that's a different thing. That only will qualify as locus. But on 7/7, he didn't say that, but subsequently, he has come out in his counter that he is a power attorney holder of this farm that was executed on 22/2025. So for this.
While at the time of participating in NIT, whether he was a
No,
attorney holder?
no, I have got.
He was attorney holder, power of
No,
holder. No,
nothing.
but
Because
he participated in the name of some other person.
that is what he says, without any basis.
Okay.
Nothing to be substantiated. And he
Okay,
says,
okay.
so far, who has participated in a tender?
Okay. By the way, what is the stage of the investigation in the case?
Now, I don't know what states my learned friend will be able to say about investigating the case.
Whether the case has been charged with it?
No, no, my lord, because it's a case.
What is the state?
Now,
so-
my lord, some money has been seized, my lord. My lord, you can appreciate that this is a trade case, my lord.
Mhm.
So there was a demand for the money of 30%, and there was a negotiation of 7 lakhs. Now, but initially 40 lakhs was given. So this complaint was filed, and they came to the ACB office, and pre-trade memorandum was prepared. After that, the trade was late, and he was court-handed along with all those, notes, which were noted with the entire process was followed with. So it was again taken back by the agency, and we have given it for forensic science that we are yet to receive it.
Has it come back? No, not.
No, my lord.
Okay. Still under investigation that.
Yes, my lord.
My lord, I'll decipher the case.
Whether record was called for to.
No,
This
my
has-
lord,
No, my lord.
record is not called for.
Since it is under investigation, my lord.
Hmm.
So if we did a case where charge sheet has been filed, my lord, we could have done that, my lord. So even my elder brother was requesting me to file an affidavit, my lord, but since it is under investigation, my lord, and we don't know whether
Now, even
we cannot
at this
disclose.
stage also, in order to hear, probably we may have to call for the record.
Yes, my lord, because here is a case of trap. No
Now
doubt.
it will be CD only.
Yes,
Yes. So for the procedure is concerned, they have written down the pre-trap as post-trap.
Is it not too early or
No.
premature?
My lord,
Because
I am
the
going
case
to
is still under investigation.
No, it's not too early because the locus cannot be qualified. This person is no locus now.
No.
No.
See.
Yes, I can understand, but to balance, my lord,
Hmm.
I'm in the fact and service. I'm in the fact and service.
Okay.
Only 3 months left for me to go on superannuation. That I'll be returning on 31st May 2026. Now I have been kept under suspension since 18/7/2025 till now. Now, only last
It was reviewed on
it
time.
was not reviewed. So
Reviewed on time.
it was reviewed on time.
Okay.
So I'm still on suspension. Now the question is, he says that about 17A. Apparently, if it is the law is not followed, the case doesn't lie. Number 2, who is this guy? And if we go by the 7 golden rules of Vajanlal, golden rule 5, 6, 7 will squarely cover my case.
Now, if the person is taking bribe, maybe representing others, but only because
No,
he
that-
has,
that-
only on the locus.
no, no. I have got other things also, no, apart from the locals.
Hmm.
Apart from the locals.
Hmm.
Because all my stain is that I had a personal relationship, financial.
Which is
No.
denied by the
No.
respondent.
His denial will not come into play. Because
No.
I have got also my
You
stain.
don't have any record also.
No,
that-
The record may be called for, CD may be gone through.
No, you don't have any record that it was personal loan. Yes.
Yes, that to that extent, I say that I don't
And
have the
then,
record, but it was
although you
witnessed
have a
by my
witness-
wife.
Although you have a witness.
It was witnessed by my wife. That is a different aspect of the
That
matter.
will be interested. but-
That is a different aspect of the matter. Now, even if we go by the very version of the FIR, if we go by the version of the FIR, he says he participated. See, anybody can file a criminal case.
Now, your prayer, what is your prayer? Setting, question of
Just
FIR.
FIR.
At this stage, is it possible?
No. Milord will say is little early because please consider my case also. I'm in the faggot of service, and I have been trying. My humble submission is that throughout my career, Milord would not find even a single whisper about alleging me. Now, at the faggot of service, Milord, this has been true. Then, and they said in the name of there is a pre-trap and post-trap, Milord. I'll come to that also. There are good law points. If a course of action is not met out, and if that is only to take revenge on me, and if that is not barred by the law.
And one thing, this is a trap case. Yes. Then it was a prima facie.
No, that
On the
prima
spot
facie-
only.
No, yes. Then
On the
that
spot only.
no, that prima facie case, my lord, I'll come to that also. Because if it is barred by law, because 17A says that if this decision where I have not given this money is because of the 2025 that allocation has not come. I have frankly said that money cannot be given. So when I say that this money cannot be given, from where the question of again the bribe things come. Because the entire record will reveal that so far this particular, let's not go by this complainant. If we go by this, so far this farm is concerned, he has got a remaining amount of 10 lakhs to be paid. His due amount is 10 lakhs as per the official record. That's I have gathered the information from my client, 10 lakhs.
10 lakhs due to whom?
To AT Enterprise to be paid out of the balance amount. This 10 lakhs
By the government.
by the government. This 10 lakhs has to be disbursed from my department, that is EE on my capacity. Now this 10 lakh, my lord, can it be?
But there was no fund.
For that there was no fund.
Okay.
And that is the allegation, and for that allegation, whether you will pay 7 lakhs to get 10 lakhs? My lord, is it is humanly possible that just to get a 10 lakhs, you will bribe me by paying 7 lakhs?
This involves with the fact.
My lord,
Trial court will decide.
no, yes. One thing, if we go by the extent that the trial court will decide, again, what will be my fact? And if I can make out a case that prima facie
Now-
case doesn't lie.
Now, see, the person is retiring and the department, it appears, knows.
Yeah, my lord,
The department who extended also knows, probably,
my lord,
unless there is some other intention.
my lord.
And will file charge it as early as possible.
But then, my lord, we can file the charge sheet, my lord.
Hmm.
Here, there are two things, my lord. Now, just filing the charge sheet will not do. And we need to have the entire document, my lord.
So that is
The
why.
entire documents, my lord.
Hmm.
And then apart from that, my lord, we have to seek for the prosecution sanction, my lord. And for that also, we need the, I mean, the.
Now, see, the person is retiring.
My lord,
Unless you have an intention to cause unnecessary harassment.
my lord,
See, prosecution sanction, if he is involved, can be obtained.
my lord.
And then charge it. If there is nothing, file final report. And if there is anything, and then considering that this is urgency, file charge it, keeping open for filing supplementary.
My lord.
That can be, because the person is retiring.
Sure, my lord.
So it's only the, see, retiring and then knowing that he is retiring, not filing charge sheet on time or extending would amount to causing unnecessary harassment only.
My lord.
So you have to, the department has to know, because knowing that he is retiring, it will be difficult for a person who is retiring, because he will, if he is not involved, he will be surviving the amount only, the retirement benefit, and if that is debarred, it will be difficult for
I
him to
appreciate that,
survive.
my lord. I truly appreciate, my lord.
Hmm.
But my lord, we kindly see the legal point, my lord. There is a trap case, my lord. There was a complaint. There was a demand, my lord. In trap case, my lord, there has to be demand, my lord. And the demand is, and there has to be an acceptance, my lord. And there is to be recovery, my lord.
Yeah, of course, I don't know exactly, but then if the bill was only
My lord.
10 lakhs and to be released only after 2025, 26, and then we pay 7 lakhs only to get 10 lakhs is also not possible.
No, my lord. I think the bill
No,
is,
my lord, I'll come to the facts.
bill is, I think, 70 lakhs or 80 lakhs.
No, 10 lakhs only, the record will reveal.
Okay.
Even
Then
he has
see,
said
see,
10 lakhs.
This appears entire matter, your case probably would be solved only after the entire trial.
My lord, no,
case
my lord,
Otherwise,
my,
at this stage,
no, my humble
in a
submission.
quashing
my lord,
petition,
My humble submission.
while the case is
Why-
still
why
under
I have come for-
investigation, how do we,
My lord, I'll convince your lordship on 13.
when there is a prima facie case,
No, no,
especially?
my lord, this prima facie,
Hmm.
so for RP Kapoor case also has considered,
Hmm.
if it is barred by 17A since this, my lord, I'll just read out 17A because I'll go to the matter case on 13 if the lordship permits, or if can accommodate on 13 because I'm coming on 12 for the election matter.
13,
So,
okay. Okay, we'll fix it 13.
My lord.
So the record will be called for that in that
maybe
case?
all the entire, maybe
Okay.
because 17A is
Mr. Singh, Line Council for the petitioner. MG Singh, huh? Thank you, Petitioner. Also, Mr. Opada, Line Council, Line Standing Council.
NIT to comment.
So this is. Standing Okay. And POSI is for whom?
Yeah, private respondent.
Private respondent means the complainant,
Yes,
the
yes.
informant.
Yes.
Okay, it seems you are So enthusiastic.
He's denying that they have any, he has
Okay,
lended any,
proceed for the-
money from there.
He has been implemented as a private respondent.
Yes, yes.
Okay, private respondent. Respondent number 2.
Yes.
Okay. The counsel for the parties. It is submitted that the trial court, the case diary would be necessary. Earlier called for, no.
Earlier it was not called.
It was not called.
No, it was called for only, called for the case diary. On the first day, call for the case diary.
It was brought, my lord, but I think,
Okay,
another, there was a valid,
Okay.
I think so, and that was.
Mr. Opera. Okay, list it again on
13.
eight agreed upon by the parties. List it again on 13. On which date Mr. Opada and the standing council shall produce the updated case diary. Okay.
Obliged, deeply obliged.
Obliged.